Please, Your Lordship.
Yes.
Your Lordship, I beg to mention
For judgment, item number 15.
Petition stands allowed and it is directed to dispose of the matter preferably within 6 months.
please, Your Lordship. Your Lordship, I beg to mention item number.
I'll put my signature afterwards. Please just give it. One page I have put. Yes, which
I
one?
beg to mention item number 3 and 4.
3 and 4.
Yes, Your Lordship. State is yet to file affidavit, so kindly grant me 3 weeks' time to file my affidavit.
You're representing the state?
Yes, Your Lordship, for the state respondents.
Okay. Heard Mr. Enso, the learned counsel appearing for the petitioner, and also heard Mr. Enso, the learned government advocate. Praying, and she prayed for 3 weeks. How many weeks?
3 weeks, Your Lordship.
3 weeks time to file their affidavit in opposition. To which the petitioner learning counsel for the petitioner raised no objection. List accordingly after 3 weeks. And the respondent government to file their affidavit in opposition. Okay, it will be listed
Much
after 3
appreciated.
weeks.
Hello.
My please, Your Lordship. Lordship, I beg to mention item number 5. I'm for the respondent. Your Lordship, we are yet to file an affidavit in opposition. So 3 more weeks time be given to me, Your Lordship.
So you're the government side?
No, Your Lordship. For the
Private
union.
respondent?
Yeah.
Private respondent?
No, Your Lordship, for the center, for the union.
No, you're representing the petitioner side or the respondent?
For the respondent, Your Lordship.
So you're for the private respondent?
This,
Lordship, I'm for the petitioner, Lordship.
So give me the,
They're yet to file
Record,
counter
record.
affidavit.
give me the record. Now see, there are respondents in the say Union of India, Director General of Police, Inspector General of Police, the Commandant and the IGP.
Yes,
So
Your
you're
Lordship.
representing all.
Yes, Your Lordship, for all the respondent.
You are CGSC?
No, Your Lordship. I'm standing on behalf of my senior, Gauhati, Your Lordship.
Acha, acha. Heard Mr. Swenso, the learned counsel for the petition, and also heard Mr. Swenso appearing on behalf of. You are appearing on behalf of
Gauhati, Your Lordship.
Swenso. He is CGC.
Yes, Your Lordship. He says CGC.
He is CGC for the respondent and submitted that. How many weeks you need?
3 weeks, Your Lordship.
3 weeks is needed to file their affidavit in opposition. To which the learned counsel for the petition raised no objection, list accordingly after 3 weeks. Same order enabling the respondent government side to file their affidavit in opposition.
Bless, Lordship. Bless, Your Lordship.
May I please, Your Lordship?
Yes. You are in which item?
Item number 12 and 13, Lordship.
Item number 12 and 13.
Lordship.
These two are hearing matters, yes? What a problem?
Lordship, the principal counsel, Mr. Likham, is in bereavement, Lordship.
Who is the counsel? Likham.
Likham, Lordship. He's in bereavement, Lordship.
Yes, yes. On last 2 occasions also, we have adjourned some matters as he is in bereavement. So you are for the petitioner?
Lordship.
Yes, for the respondent, Lordship.
My senior,
Respondent number 1.
I have here Lordship Senior Advocate Hasibur Rahman.
Your senior is appearing through?
VC.
Acha, acha. Mr. Hasibur Rahman
Yes, Senior Advocate Hasibur Rahman for the petitioner.
for the petitioner. So now they are seeking adjournment in these 2 matters, stating that Mr. Likham is still under bereavement. Do you have any objection?
Then how I can.
Court is ready to hear him, right?
Family, it is.
Because I have joined, my list since last Monday, most probably I'm giving a time for, Mr. Likham because he is stated to be under bereavement. So, okay, then let's have one. Okay, Mr. Raman, any?
Yes.
Otherwise, court is ready to hear. If you want to.
I am also ready to, I am also ready to argue, but unfortunately, when there is a bereavement in the family, I
Yeah.
must consider it.
Okay, yes, sure. Heard Mr. Hasibur Rahman, the learned counsel appearing for the petition, and also heard Mr. Swensu appearing on behalf of Mr. N.K. Likham, and it is and prayed for an adjournment stating that Mr. Likham is still under bereavement, to which Mr. Rahman raised no objection. Accordingly, how many weeks you now need? Yes, Mr. For respondent.
Lordship, let the petitioner counsel decide because he's an outstation advocate.
Okay, yes, sure. Yes, Mr. Rahman.
Sir,
In the second week of September.
Second week of September. Do you need any fixed date because you are from the
Yes,
outside?
Lord. Any date, any date.
Any date? Any fixed date on second week of September?
9. Yes,
Is saying 9 will be convenient, 9 September?
any date is fine, Lordship. Let it be as per the convenience of the court.
9 will be convenient for you, Mr. Rahman?
yes.
Okay. Mr. Rahman, senior advocate, dibo, huh? Senior advocate assisted by
I, Jamir.
Ijan. 9th of September. Okay, we are fixing it on 9th. Both the matters.
Much obliged, Lordship.
Yes.
May I please, Your Lordship? Lordship, I beg to mention item number 19, item number 9. We will be filing our affidavit on behalf of respondent 3 to 7 during the course of the day. Kindly list this matter after 2 weeks.
You was representing state respondent or
As private respondent.
private respondent? State has already filed?
No, still yet to file.
Yet to file. Heard Mr. Swenso, the learned counsel for the petition, and also heard MS Swenso, the learned counsel appearing on behalf of state, appearing on behalf of private respondent and submitted that they need some time to file their affidavit in opposition. At the same time, Mr. Swenso, the PP, PP Nagaland, representing the state respondent, submitted that they are yet to file their affidavit in opposition and accordingly needs some time. List both the matters accordingly. How many weeks you need? 2 weeks?
2 weeks.
List after 2 weeks, you'll be able to file your affidavit in opposition?
Project 2 weeks.
2 weeks, list after 2 weeks. Enabling both the respondent side to file their affidavit in opposition.
May I please, Your Lordship. Your Lordship, I beg to mention item number 10. As the last order 3724, Your Lordship, we had already taken a first step on issue of,
Item number 8, let me give the record of item number 8.
Your Lordship, item number 10.
Oh, you're for item number 10 or 8?
10,
10,
Your
10,
Lordship.
10,
So-
okay, 10. But as per the office note, you have not taken any steps.
Yes, Your Lordship, the court has directed us to take a first step on issue of notice to the respondent number 5, Your Lordship. And we have already taken a steps, Your Lordship.
So you were directed to take steps on respond number 5.
Yes, Your
As
Lordship.
per office note,
Yes, Your Lordship.
you have
Yes.
not taken steps.
Your Lordship, we have already taken steps in 2 occasions. First, we have taken Dusty Services and other the registered boss, through registered boss.
No. Last order was of, you were directed by last order is 3/6. when you are directed to take steps. Again on 2/7 also, you are directed to take fresh steps on respond number 5. But as per office note dated 25/7, no steps has been taken.
Is,
I don't know, the office has not received your steps. I'm talking about the office note. Office note is of 25/7
Your Lordship.
and 25/7, you have not taken any steps. Can you make an inquiry whether they have, you have taken steps? Can you tell us the date?
Yes, Your Lordship, I actually can't remember the date, but we have already taken steps.
Do you have the acknowledgement received any?
Your Lordship, I haven't brought out the file, so I can't remember the
You
date.
have to inquiry matter because as per the office note, you have not taken any steps. As per the office note, I'm taking.
Yes, Your Lordship. But Your Lordship, I've taken steps in 2 occasions. First, the DASI service and then other the register, through register.
Yes, on respond number 5 only.
Yes, only,
We are talking about the respond number 5 only.
yes, Your Lordship.
How can you say you have taken steps? It's not here only. Is there any? If you have taken dusty also, you have not filed any affidavit, nothing is there. So how can you say that you have taken steps? It's not here.
Okay, then, Your Lordship.
Take fresh steps because as per office note, I'm not talking about the other thing, but we may inquire about, obviously, if there is steps taken by you only, then it's okay. But Dusty also, have you filed any affidavit in regards to Dusty service? No,
No, Your Lordship.
then how can you say? Okay, heard Mr. Swen, the learned counsel for the petitioner. And also heard, you are representing
The state response,
state respondent, also heard. You are for 1, 2,
3 and 4.
1,
1
2.
to 3.
And when it was taken, 5, 6, 5th of June. To register it. Okay, let us keep this one. State respondent, post of, as per office note dated 25/7/2024, no steps has been received by the registry against the respondent number 5. However, it is submitted by Mr. Swenso, the learned counsel for the petitioner, that they have already taken steps for the respondent number 5 in pursuant to order dated 3/6/2024 and 2/7/2024. To registered AD, full stop. On inquiry, it is seen from the record that the steps have already been taken through registered post on the respondent number 5. On respondent number 5, but no report, no report has been received. But no service report is received on for the same so and so. In that case, we can await for service. Service be awaited then till next.
Yes, Your Lordship, yes, Your Lordship.
Service be awaited till next date of listing. List accordingly when it can be listed.
Your Lordship, after 2 weeks.
After 2 weeks, list after 2 weeks. Okay. As per the here you have taken steps,
Yes, Your
but office note most of they forgot to enter the steps.
Yes, Your Lordship. Oh, bless Your Lord.
Your Lordship, I beg to mention item 11 on
Hmm.
behalf of Ms. Pichano, government advocate. As
Mr.
she,
On behalf of
Ms. Pichano,
Miss Pichano.
Yes.
Naam to likho.
as she's indisposed, kindly list the matter after 1 week, Your Lordship.
If Lordship, I can take up on Tuesday, Lordship. 13, Lordship.
Tuesday, 2-3 matters are already being.
Monday,
fixed.
Lordship, in this case. Monday, Lordship.
Monday, I have matters from the principal seat also. She will be able to. Otherwise, next week it may be better, I think. Because it is a hearing matter, we don't want to keep it as a CAV. We want to dispose it.
Lordship.
But if hearing would have been completed today, then definitely it would have been disposed. But whether she will be able to Monday may be a bit difficult because I have a thing from principal seat also.
Lordship, Lordship.
Through VC. And then the other matters are there Tuesday, Wednesday. Now tell us if she can. Otherwise we'll take it.
Lordship, in that case on 22nd, Lordship. 22nd after 2 weeks, Lordship. Because even on 16, I have some difficulty, Lordship. I have a fixed matter before a lower judiciary, Lordship.
On 16th.
Lordship.
16th will be difficult for you.
Yes, Lordship. 22nd, Lordship.
22nd, Your Lordship.
22nd.
22nd.
And a request made by so and so. Kiba naam to likhi sir? Is in benefit. Is in this post. So we are listing it on 22nd.
Lordship,
It's a matter of 2020, so
Lordship.
better to be a matter.
Lordship.
oblige Lordship.
Lordship, I also like to mention item 8 on behalf of Mr. Tibabong, Government Advocate.
Lordship, I am appearing on behalf of respondent number 5 for the first time. I have instructions to appear on behalf of the respondent number 5.
You
So,
are for respondent number 5.
yes, I'll be filing my power. So 3 weeks may be granted for filing affidavit.
It will be recorded. It. So from whom you are appearing for the first time?
For the
Respondent
respondent number
number?
5.
5.
Yes, the private respondent.
And state is representing 1, 2, 3, and 4.
Yes, Your Lordship.
So have you filed your
No, Your Lordship, we are yet to receive instructions.
need to
We will
receive
pray for 3
instruction?
weeks' time.
And you will be also be filing?
Yes,
affidavit?
Your Lordship.
For petitioner who is appearing?
I'm appearing for a petition.
Petitioner. By Mr. Spencer, the learned counsel appearing for the petition. And also heard, you are Mr.
Tong Pok Owner.
Mr. Tongpo Pone, the learned counsel appearing for the private respondent number 5 and sought some more time to file their affidavit in opposition. In the same time, Mr. So-and-so appearing on behalf of the government advocate also submitted that he needs 3 weeks time to file their affidavit in opposition for the state respondent. Allowed after 3 weeks will do,
Lordship.
list the matters after 3 weeks, enabling the respondent side to file their affidavit in opposition. Okay.
Oblige, Your Lordship.
For admission, item number 1.
May it please your lordship. Lordship, this is a appeal against a judgment passed by the Honorable Special Court Poxco,
Yes.
Mon District, Nagaland.
Hmm.
In this matter, I was convicted for sexual harassment, and the quantum of punishment was 13 months, 3 weeks. During the course of trial, I had undergone the detention period, and after the judgment, I was enlarged. So I have completed my period of detention. Now I was a teacher in that particular area, and I was serving for almost 20 years in that area. Now, because of this particular judgment and allegation against me, and because of this conviction, I am in suspension and I am without job and salary since last 2 years. Now, lordship may kindly refer to page number 40 of my petition.
May I please, Your Lordship? Lordship, I for the respondent, Lordship. Since today I'm not giving one, Lordship, if this matter can come up next week, Lordship.
And then we can do one thing. Otherwise, court is ready to hear. It can be the matter may be admitted for hearing otherwise because
Lordship,
it is an admission hearing.
Lordship.
As an appeal against so and so. So now your petitioner is, I mean, he has already spent his hearing.
Yes,
I mean,
during the course of trial.
He
in
has
fact,
already.
And
What are the other sections? Section 8 and 1354A.
section 8 and 12. of POCSO.
8 and 12.
POCSO.
Okay.
And if he doesn't go for hearing, then the
Okay.
matter may be admitted.
You are Mr. You are Mr.
M. Das Gupta.
Heard Mr. M. Das Gupta, the learned counsel for the appellant, and also heard Mr. Swenson, the learned BP, appearing on behalf of state respondent. Here, the respondent, other respondents are any?
We
You are
have taken
appealing.
we have taken the steps. The
These
other
are because it's a
respondent is the-
POCSO, that's why I'm asking.
Dusty service was taken and the informant was served, notice was served to the informant.
So no one represented.
No one represented.
Why name is there? I mean, she is a victim or the.
She is the informant, mother.
It is submitted by Mr. Dasgupta that though the service steps was taken for the respondent number 2 / informant, even through dusty service, but no one has represented the respondent number. Do you want that she should be represented by any amicus or?
Lordship, in fact, it has to be represented, Lordship, since.
In that context, this court finds it necessary to represent the respondent number 2 through an amicus. Do you have the list or registry will appoint anyone? Registry will. In that context, registry will do the needful in appointing an amicus curiae to represent the respondent number 2. Next, considering the submission made by the learned counsel for the appellant, the matter is admitted for hearing. List for final hearing, it will be.
No.
Yes, when it will be convenient for you.
Since I'm traveling from Gauhati.
That's why,
so,
that's why I'm asking.
You can fix
Next
it.
We take a fixed date because you are from Gauhati.
Yeah.
Otherwise,
Month of September last week of September.
last week of
Or mid-
September. Mid of,
mid
mid
or
of,
mid
of September, any date,
mid of September.
fixed date. Seventeen or 18 can be?
18.
18?
18.
18 is a division they match. Otherwise, you
19.
take it on
19?
17 or 19th?
19.
19 September.
Can it be 9th, Lordship? 9,
09.
yes, 9th of September.
It's okay. You are saying the mid of, that's why I'm asking. 09.
Good.
09.
Like,
You're going back today or you're staying? Huh?
Today.
Today, sir. Whether you see the weather.
Like,
For admission item number 2.
Here also same prayer.
Lordship, on behalf of my colleague, Lucas Lordship. The state I'll counter affidavit, Lordship.
May I please, Lordship?
Hmm.
Lordship, there is an urgency in this matter, Lordship. This matter is pertinent to regularization, and this is the second round of litigation, Lordship.
Hmm.
So as per the office memorandum 1703/2015, those who have completed 30 years of service, they shall be automatically regularized. So being completed 30 years, the petitioner issue and representation for regularization of his service, but nothing was considered. He was not considered. So being aggrieved, the petitioner filed a writ petition numbering WBC 159 of 2022, which
Earlier.
was disposed of with the direction to regularize the petitioner within 2 months. And after the state respondent authority, considering the case of the petitioner, submitted a letter to me saying that my service will be regularized. And my service will be regularized. So while I was waiting for my regularization, I was retired. So before I retired, I submitted a representation for me to regularize, but nothing has been done. And for the past 2 months, because of this pending writ petition, I could not proceed my pension and also. So the
So
petitioner,
if there was an order for your regularization
Yes,
and
yes.
if the state has not
My name
complied
was-
with the order,
yes, sir.
then why didn't you prefer any contempt or anything?
No, Lordship, they have considered saying that my service will be regularized. So while I was waiting for it, so only a few months was left for me to be retired, so I submitted another representation saying that since my service will be retired in few months, so my case will be considered, but nothing has been done. So during that time, I was retired.
So this is the second.
Yes, this is the second round of litigation, praying for regularization of my service.
Obviously, otherwise you will not get the pension benefits also.
Yes.
If your regular is not regularized,
Lordship.
may difficult on your finance. But yes, what is your plea?
Lordship, since the state is yet to file counter, Lordship, 3 weeks time may be given, Lordship. In the meantime, we'll file a counter.
But now see his position, because obviously it is a urgent matter as
Lordship.
from his statement. So stated representing 1, 2, 3.
One-
Huh?
All the
Yes.
respondents.
All the
All
response,
the respond, 4
All
and
the
5 also.
Lordship. 1 to 5.
So now you got retired when?
Zero 9/11/2022,
2022.
Lordship.
Heard Mr. Swenso, the learned counsel for the petitioner, and also heard Mr. Swenso, the learned. You are
Lordship, I'm mentioning on behalf of my colleague, Livika Singh. So if
government
her name may
be
be
appearing on behalf of Swenso, the government advocate for the respondents, and it is submitted that the state respondent is yet to file their affidavit in opposition and needs 3 weeks time in that regard. Next, Mr. Swenso, the learned counsel for a petitioner submitted that this is the second round of litigation and due to dependency of this case, the petitioner, his service is not yet regularized and he is not even getting his pension benefits, though he got retired in the year 2022. Accordingly, Mr. Swenso submitted that the matter is urgent and need for urgent hearing, and matter is urgent first. Next para. Considering the submission made by the learned counsel for the petitioner, the state respondent is hereby asked to file their affidavit in opposition on or before the next date of listing. On or before the next date of listing post. List accordingly, you need after 3 weeks.
Lordship.
List accordingly, file your affidavit in
Lordship.
opposition, try to get, because matter is urgent for him.
Lordship.
Obliged.
For admission, item number 6.
Yeah, please, your lordship.
Yes.
Lordship, in this matter, I have not received a service copy from the petitioner till then.
You have not supplied? You have not supplied?
I thought I had Lordship. I was finishing copies, Lordship.
So you have not filed your affidavit in opposition?
No, lordship, I have not received even service copy, so.
I'll
One
serve it
train-
by Monday, the requisite number of copies.
One copy will do, I think state respondents are there only. If you have already furnished.
Yes.
Hi, Mr. Swenso, the learning.
Lordship, kindly grant 4 weeks of time to file my affidavit.
And Swenso, the learning counsel for the petition, and also heard Mr. You are a government advocate,
Lordship,
a good name,
Ajungli.
Mr. Arjuni, the learned government advocate representing the state respondent. And he submitted that he had not received his service copy till date. Accordingly, Mr. So-and-so, the learned counsel for the petition, has already served a copy to the state respondent, to the learned government advocates representing the state respondent. Mr. Rangchu further submitted that he need 4 weeks time.
Lordship.
He needs 4 weeks time to file their affidavit. in
Lordship,
opposition.
it can be 3 weeks, Lordship, because this is a short matter. It relates to compassionate appointment.
No, Lordship, but to get instruction, it take.
Now see, he is furnishing your copy today itself, he is not waiting for Monday.
No,
So
some
you also
shortages.
don't wait for 4 weeks, try to get. it
Lordship,
back.
I have received half only. I got only 2, so I need to serve 3 out there. Still, I have received only 2 copies.
You can take instruction, how many? So see,
Lordship, kindly grant me 4 weeks. Lordship, sometimes it's really difficult to get instruction. And if I keep on taking time, sometimes it's
you
impression.
have
is not
more
good.
copies, I think, with you.
Lordship, if,
Far more copies are with you, I think.
yes,
Okay. Then tell us what to do, 3 weeks, 4 weeks.
yes, 3
whatever.
weeks, Lordship, because Lordship, if they take long adjournments, Lordship, by the time they take 3 or 4 adjournments, 2024 will be over. Yes, and this is a matter of compassionate appointment, Lordship.
Compassionate appointment.
Yes, Lordship.
Here in state of Nagaland, compassionate appointment is still going on, na?
Yes, Lordship.
In Assam, what we have now at present,
Yes.
and one notification was there in the year 2000, I think 16 or 17. I think.
Yes, yes,
From there only we stopped compassionate appointment.
Lordship.
And instead of that, what state government is doing, they suppose there's someone died is at the age of suppose 45 or 50 years. So he will have to 60 years of age of superannuation.
Yes.
So till 10 years,
Ah.
the family members who is the main nominee,
Okay,
some
okay,
wife
okay,
or
okay.
children, whoever,
Ah,
he will get he or she will get the entire service benefits
okay.
for the person till the age of superannuation. So
Oh.
there's no compensate appointment, but
Ah.
otherwise the family will be very much
Yes, yes,
benefited. by
yes.
that.
I think that's a very good scheme.
Very good,
Ah.
very good scheme.
Ah,
So compassionate is not there, but that is there.
yes, yes.
If a person dies in a size 40, 45
Yes,
years, the entire family
Ah,
will suffer,
ah.
so that is there.
Okay, we have that whole system of.
It's still,
yeah,
still
yes, yes,
prevailing, still
compensation,
prevailing.
yes,
That's
yes.
what I'm asking.
Ah.
Anyway, let us give 3 weeks. Okay, we'll do.
All right. But Lordship, if
Then
I
you will
keep
again-
on
again-
adjourning, it's
you-
the same thing. Since I have to receive the instruction, I have to prepare affidavit and I have to send to obtain the signature and I have to drag back. And I have to file.
Lordship, I think, Lordship, if my learned friend can make communications verbally also, I think this matter can be disposed of. There are types of cases, class of cases, Lordship. In this kind of case, I think affidavit may not even be required, Lordship. Because the respondents, to be fair, they have also processed to some extent for
Oh,
my
very
compassionate
nice.
appointment,
Okay,
yes,
okay, very nice.
yes,
If it is there, then he will take instruction. Okay, then this time we'll give him 4 weeks time.
yes.
Let us take the instruction,
Okay.
and if the instruction is about, if we file the affidavit in the
Lordship.
admission stage, then it
Lordship.
can be listed
Lordship.
just after 4 weeks.
I'm obliged.
For orders, item number 7.
Yes.
Lordship, I am for respondents 1, 2, and 3 here, Lordship. I have already filed my affidavit in opposition on 27th of February.
May I please, your
One-
lordship?
For 1, 2, and 3.
Yes,
You're for a
Lordship.
petitioner.
Yes, your lordship.
Hmm.
Your lordship, we were instructed to take dusty upon respondent number 9 by order dated
So
2/5.
how many altogether, how many, respondents are there?
9 respondents, your lordship.
9. You are representing 1, 2,
1, 2, and 3.
1, 2, and 3. State is representing anyone?
4, 5, 6, 7, and 8.
One, 2, and 3, they have already filed. Then 4,
4 to 8 is the state, your lordship.
no. Privates are,
Private respondent is
no. So you are for 1, 2,
1, 2, and 3. I'm for the union.
NHIDC.
Yes, my lord.
So 1, 2, 3, and 4.
1, 2, and 3.
1, 2, and 3. 4, 5, 6, and 7, 6, 7, and 8.
Lordship.
Oh, private is only 9.
Yes, your lordship.
The stay is already completed?
Yes, Your Lordship. We filed our affidavit on 8/7/2024.
You have filed your affidavit?
Yes, Your Lordship.
8/7.
Yes, Your Lordship.
Heard MS so-and-so, the learned counsel for the petition. And also heard Mr. So-and-so, the learned counsel appearing for the respondent number 1, 2, and 3, representing the NHIDC, and it is submitted that he has already filed the affidavit in opposition on behalf of 1, 2, and 3. Mr. So-and-so, the learned government advocate, representing respondent number 4, 5, 6, 7, and 8. You have also filed your affidavit in
No.
opposition?
We will file.
Yeah, you will file,
No,
not yet filed.
not yet.
Not yet filed, submitted that they are yet to file the affidavit in opposition on behalf of respondent number 4 to 8. Next, para, MS so-and-so further submitted that they have already taken, the respondent has, no, sorry, petitioner has already taken steps through dusty mode on respondent number 9, that is the private respondent, and in regards to service of the notice, they have already filed their affidavit on 8/7, on 8/7/2022. Does it is seen that service is already completed? It can be listed for admission then?
Yes, my lord.
List the matter accordingly for admission hearing. And you, how many weeks you need to file your affidavit in opposition?
I have already filed.
Oh, you have, your state is there, okay. How
3
many?
weeks time.
3 weeks. List after 3 weeks, list in the admission column.
Lordship, I have a request.
Yes.
If my name can kindly be entered in the order, because for
No,
appealing.
we will enter all these orders,
My lord.
but this may be a bit for me to pronounce the true spelling. That's why we have just kept it. We'll take all the names. Those will be reflected, obviously.
I am obliged.
Much obliged.
Names are not so familiar for me, so that's why I'm taking some time. That's
For hearing item number 14.
May it please, your lordship.
yes. Yes,
This revision petition, it pertains to an injunction.
Injunction,
Yes, in a title suit which is currently pending before the civil justice. Union
Still
Region Court.
pending?
Yes. In short, the title suit was filed in March 2024. Along with it, I filed an application for injunction. Now, despite the trial court coming to a finding that I have a prima facie case, as far as the construction of work which had been carried out by the defendant number 1, it has not been allowed. So defendant number 1 has been allowed to continue with the construction work. Aggrieved with that, I filed an MCA, miscellaneous civil appeal, before the district court. It has been rejected. Aggrieved by that, I'm here before this honorable court. Now, the impugned order is at page, impugned judgment of the learned district court is at page 21 of the petition.
21.
Yes, page 21. Date of judgment is 27th May 2024.
Okay, this is Jesus.
Without assigning any reason as to how the learned trial court had come to a finding, despite coming to a finding that the plaintiff had a prima facie case, without giving any reason as to why the
Except prima facie, what are the decision on other principles?
on the irreparable injury and the
Irreparable and
inconvenience
other
are
one?
concerned, the trial court has held that in view of the certain portion of the earth which has been dug by the defendant number 1, and the defendant number 1 having submitted that in view of the upcoming monsoon, the land may be subjected to damage or wastage. Now, the defendant number 1 had prayed for constructing a retaining wall. Now, I have no objection to the construction of the retaining wall, but what the learned trial court had done is that it had misdirected in understanding as to the principles concerning the irreparable injury as well as the balance of inconvenience, and had allowed the defendant number 1 to continue with the construction activity without any limit, Now, the defendant number 1, pursuant to the finding of the trial court, had erected some RCC walls to undertake a permanent construction. Now, I filed appeal. Now, during the pendency of the appeal, that activity has been stayed. Before the revision, before this honorable court, by order dated 31st
May, 31st May, 2024.
This order?
Yes,
This court's order?
yes, this court's order,
When order dated?
31st May,
31st of May.
yes. At page 3, yes, main petition.
Yes, I have,
Main
yes,
petition, yes.
31st of May.
At page 3, now the court had clearly observed that the defendant number 1 cannot be allowed to continue with the construction activities. Now, as far as the retaining wall is concerned, the Honorable Court has fairly observed that if there's a risk or risk of damage being caused to the suit land, now the defendant number 1 can carry on with the retaining wall at her own risk. Now, as of today, the retaining wall is completed, and further no other construction activities is
So
being
by
continued by the retaining wall.
31st of
An interim order was passed.
interim order
Yes.
was what to maintain status quo?
Yes, to maintain status quo. Now, if Lordship permits me, then I can go into the facts and the circumstances of the case, but as far as the petition is concerned, the interim order is satisfies the concerns and the interests of both the parties in my humble submission. Now,
So
the,
till now, they have completed the retaining wall,
yes, it
construction of
completed,
retaining wall.
yes, I can also.
And thereafter, they, as per order of this court, they are still maintaining status quo. there.
Yes, yes.
So now you're yes, what is your
Now,
now?
the only concern is let the status quo be continued to maintain during the pendency of the suit. In the suit, written statement is yet to be filed by the defendant number 1. D2 has filed his written statement. Now, if your Lordship wants to go into the controversies, then I can go into it, or allow me to take your Lordship to the trial court's order.
Yes,
Since the trial court had summarized the disputes in a concise manner, I think there'll be more to proceed. At page 59,
50.
59.
It's a very long order.
No, the submissions have been recorded in a lengthy manner, but the.
Oh, this is 59 is the order.
Yes,
Okay,
59 is the trial court's order,
okay.
17/4 to 2024.
Hmm.
The discussions, decisions, and reasons, it's at page 69, the analysis of the trial court. In short, the facts is that in the plaintiff, he bought the land from the defendant number 2 in 2003. Now that has not been disputed. D2 has filed his written statement admitting that yes, I transferred the land, my land, to the plaintiff. In 2005 and 6, 2005, 2006, the plaintiff and the defendant number 1, they are biological sisters. As the defendant number 1 resided around 1 kilometers away from the suit land, she offered to the defendant number 1 to purchase her land at the same price from which the plaintiff purchased from D2. She agreed. She sold the land which she was residing then, and she came to reside in the land which the plaintiff bought from D2. As far as this is concerned, there's no dispute. After that, after she's settled there, she paid only 50,000. The full sale consideration in the plaint is 3,75,000, but she paid only 50,000. Now, despite the demand of the plaintiff, the due one refused to pay. Thereafter, in 2012, after the plaintiff and the defendant number 1's father passed away, plaintiff visited due one. She told her that she's ending the oral agreement. Now, this happened in everything in oral. Even the transaction between the plaintiff and the D2 is oral. The transaction between plaintiff and the D1 is oral. In 2012, plaintiff visited her sister and told her that since she was refusing to pay the full sale consideration, she was ending the agreement between the plaintiff and the D1. So she told her that there are 2 portions in the suit property, in the land which the plaintiff originally bought. Now, one part the D1 was residing. There was already an Assam type house. So there D1 was residing. In 2012, I told the D1 that where she is residing and where she has develop this part of the land, that she may reside there, but on the left-hand side, that will not be given to her. So that the left-hand side is a suit property. In the plaint, I've also enclosed in the revision petition, I have drawn a rough sketch map. Now, that was the end of the contract in 2012. In 2014, I saw that the D1 had started to undertake some construction activities. So I told her to lay off, since the land does not anymore belong to her. That is the suit land. Thereafter, I filed a complaint before the local elders of our KEL. The plaintiff and the D1, since they are biological sisters, they belong to the same KEL of Kohima village. Now, in Nagaland, we have this practice where the KELs, they can also take up civil disputes. The Gamburas they can take up civil disputes. Now, what happened to the complaint was that for 3 or 4 years, that complaint was not taken up. Only in 2018 or 19, as averred in the plaint, the Gamburas, they told the plaintiff that since my husband is from a different village and not from Kohima village, they cannot take up the dispute. That was the end of the matter. In 2019, before the onset of the COVID-19, I tried to dispose of the suit land. But a survey was conducted. There were some interested buyers, but the COVID-19 set in, and then that sale could not materialize. In 2014 March, this year of March, D1 started to dig the earth to undertake the construction activities. At first, I did not know who was undertaking construction activities. On inquiry, I found that it was D1. I requested her to stop it until we try to amicably resolve the matter, but she denied my title, asserted her own title, started to undertake the construction activity. Now, pursuant to it, I filed
On
the
what
title
basis
suit.
she claimed her title over the land?
Yes.
On what basis she claimed the title over
On
the
the
land?
basis that in fact, she purchased from D2. And those are questions of fact, whether she purchased from D2 or not. But the trial court had recorded a clear
And
finding
it
that,
is her claim that she had already purchased the land from D2.
yes, but it's quite contradictory in all the pleadings so far, as obtaining from the pleadings. The trial court had recorded that, I'll take your lordship to page 69, paragraph 22. Allow me to read page 20, paragraph 22. It is not disputed that the property originally belonged to the defendant number 2. The OP, that is the D1, has relied on an agreement supposedly executed by the defendant number 2 and the husband of the OP on 9/6/2003. The OP has further averred in paragraph so and so that before transferring the suit land to the applicant, the D2 had prepared and executed the declaration agreement dated 9/6/2003 in favor of the OP's husband. This is the relevant part. Thus, this court is prima facie satisfied that the suit land was previously transferred to the applicant, the plaintiff, by the defendant number 2 before the same was transferred to the defendant number 1 by the plaintiff applicant. Now, as this is the finding of the trial court insofar as the document relied upon by D1 is concerned, as regards the document dated 9/6/2003, given the fact that the defendant number 2 has affirmed the transfer of the suit land to the applicant in his written statement, this court is of the opinion that the document can be gone into at the appropriate stage. Now, before proceeding ahead, allow me to take lordship to the written statement of the D2, which is at page 126 of the petition. Page 126 is the written statement of defendant number 2, the vendor. And at paragraph 6, the next page, paragraph 6 at page 127. This is the statement on oath. That with regard to the statement made in paragraph 5 of the plain, the answering deponent admits to the fact that the ₹2 lakhs was borrowed from the plaintiff around the year 1999-2000, and he was unable to pay back the same. Along with interest, he requested for an additional amount of ₹25,000 from the plaintiff and transferred the said land to the plaintiff. And again at paragraph 12, in the next page, at page 128, paragraph 12, that the answering deponent begs to state that he transferred the said land only to the plaintiff. He also begs to state that neither he nor his wife have transferred the said land to anyone else other than the plaintiff. So based on this, the learned trial court was pleased to hold that as far as the document relied upon by the defendant number 1 is concerned, that will be subject to trial because these are questions of fact. Accordingly, at page 23, next page, page 70, sorry, my apologies, page 70 of the petition.
Hmm.
At paragraph 23 and 24, the learned trial court discuss about the prima facie aspect of the matter. And at paragraph 25 is the finding that the plaintiff has established a prima facie case to go for trial. Paragraph 25. Further, while it is argued by the OP that there was intention of the applicant to sell the suit property to the OP, it is argued by the applicant that the possession was permissive and there was no outright sale. It is further argued that the right, title, and interest is vested on the applicant and that the OP is a trespasser. Therefore, at this stage, the above claims made in the instant application gives reasonable ground to this court to believe that there is a bona fide dispute regarding the suit land in favor of the applicant, and there are substantial questions to be determined in the present suit, which necessarily gives rise to a prima facie case to go into trial. Now, this finding has not been assailed by the D1 before the district court by filing a cross objection or filing an appeal in its own terms. But at paragraph 28, this is the contentious portion which I'm assailing at page 72. This was the finding of the learned trial court insofar as the balance of inconvenience is concerned. Paragraph 28, allow me to read. In the instant case, the counsel for the OP has stated that as part of the current developmental activities, now this developmental activity pertains to the earth which has been dug and pursuant to which I filed a title suit. The steps leading to the OP's house has been dismantled, and due to the restraining order, no work could continue as such, affecting free movement. That whereas the applicant is a resident of Kohima district, and therefore no loss or inconvenience shall be caused to her by the developmental activities. Further that, with the passing of the ad interim injunction, the construction of the retaining wall for protection upon the freshly cut earth was suddenly put on hold. The area where the current retaining wall is adjacent to other buildings above it, thereby causing serious peril in destabilizing the entire area without proper retaining wall. And with the monsoon season being on the verge of setting in, there is apprehension that the freshly dug loose soil may trigger a landslide of big magnitude, which may cause havoc unless the OP and her husband is allowed to build a proper retaining wall. The application in county is unable to satisfy this court that the balance of convenience is in her favor. On hearing the parties, this court is satisfied that there are more probabilities or likelihood of injury on the OP, given the fact that the house and the business establishments of the OP is located above and adjacent to the property and may be subjected to more damage in the event the ad interim is continued. Now, as far as this aspect of the matter is concerned, at the time when the matter was argued before the trial court, there was no evidence to show that the land they may be subjected to damage. Now, the learned trial court did not call for any commission. In the affidavit filed by the D1, there was no photo annexed. Only photos, some kind of photos were produced before the trial court in those sheets. Now, the affidavit of the defendant number 1 in the application for temporary injunction, allow me to take your lordship to that. The objection. The objection of the defendant number 1 in my IA for temporary injunction at page 102. Just one paragraph.
Which paragraph?
Page 102 is the objection, and I would like to take lordship to page 108. This was what has been sought by the defendant number 1 before the trial court, page 108, the second paragraph. Page 108, starting from furthermore.
Yes.
Yes, second paragraph. Furthermore, with the passing of restraining order, the construction of the retaining wall for protection upon the freshly cut earth was suddenly put to halt. The area where the currently retaining wall is about to be erected is situated immediately adjacent to other buildings above it, thereby causing serious peril in destabilizing the entire area. Without proper retaining wall and with the monsoon season being on the verge of setting in, there is an inherent apprehension that the freshly dug loose soils may trigger landslide of big magnitude, which may cause havoc unless the defendant number 1 and her husband is allowed to build a proper retaining wall by vacating and setting aside the present interim order. Now, this was the prayer which was made before the learned trial court. But while appreciating the question of balance of inconvenience and irreparable injury, the trial court could not have allowed the defendant number one to continue with other activities, construction activities, at least in the interest of justice and to balance the interest of both the parties, if at all, even though in the absence of any evidence to show that there was going to be a damage to the suit land, at least the trial court could have ordered that the defendant number one may construct the retaining wall. This was the apprehension expressed by the D1. But in failing to do that, a free ring has been given to the defendant number one to continue with any construction activity that she pleases. Now, that has been going on, but fortunately, this court has stayed such activities except the retaining wall. Now, therefore, my submission is that during the pendency of the suit, at least in order to balance the interests of both the parties, now since the retaining wall has been done, the apprehension or the injury, the apprehension of injury expressed by D1 has been taken care of. Retaining wall is completed, it's over. I can have some photographs to show this court. At least during the pendency of the suit, where the written statement is yet to be filed, at least the status quo may be maintained in the interest of justice.
May it please your lordship. Lordship, this petition revision petition is filed under Article 227 of the Constitutions of India. Now, before going into the facts of the case, whether the present revision petition is maintainable, that is the main issue to be pondered about it. Lordship, in gist, since the learned counsel for the petitioner who has gone back to the facts of the case, and let me just quickly add few facts of the case. Lordship, it was in the year 2003 that the petitioner and defendant number two, I'm defendant number one. Now the respondent and defendant number two is not before this court. In the year 2003, that there was some settlement transactions in respect of some loan between the two parties. And in lieu of paying that loan, that present disputed land, the subject matter, that was in fact offered to the present respondent. That was 2003. Then since 2003, since we were staying and residing elsewhere, the entire family, and since that was offered, so in the year 2003, we sold off our previous land, which was in fact our ancestral land. We sold off that one and came and purchased the present subject matter, that means the disputed land, in the year 2003. Since then, we have occupied and in possessions of the suit land till today, Lordship. Till today.
So you have purchased from whom?
I have purchased through the amount of 50,000 was paid through the defendant, the present petitioner, from the defendant number two. Originally, this land belonged to defendant number two. He's not before this court. Lordship, since 2003 till 2024, because this year, in the year 2024, only this title suit was instituted before the civil judge senior division. That means after 21 years, Lordship, after 21 years, there is no dispute. Lordship, see, by the time when I purchased the land, a document was also, in fact, by way of agreement, that was also executed by the defendant number two, who is not before this court, before the trial court, and my husband. So for the last 21 years, I have been peacefully in possession of the land. That is the first point. Since then, Lordship, only in 2024, prior to that, no complaint, nothing. Only in 2024, when the family, my family, is about to start the further construction in the suit land, then only then the present petitioner who has filed a title suit before the civil judge, senior division. Let me give the chronology of the case, how that has been coming, and now the present revision petition has been filed. Title suit number 1 of 2024 was filed before the civil judge, senior division. While filing TS title suit, an IA was also filed, and there they have obtained ad interim injunction against the present respondent. Then, Lordship, after that opportunity was given to the present respondent, we file objection. This is part of the record. I have not filed any objections, any affidavit before this court in respect of the present suit. The present records which has been filed by the petition that will cover. So, Lordship, we were given opportunity, so objection was filed against the IA and also the ad interim that was passed against us. Lordship, the civil judge junior division, senior division, by order dated 17/4/2024, this is part of record, page 59. Substantial hearing took place, and Lordship, after hearing both the parties, the civil judge senior division has vacated the ad interim passed by the court. Agreed by that, Lordship, again the present petition, who has preferred an appeal, miscellaneous appeal before the principal district judge, Kohima. And while filing the appeal, an ex parte status quo order was obtained from the principal district judge, senior division, principal district judge, Kohima. Objecting to it, that civil miscellaneous appeal was fully heard again. Then, Lordship, by impugn order, the present impugn order, by order, the order dated 27/5/2024, the principal district and session judge Kohima, after hearing all the parties, again passed an order dated, a judgment dated 27/5/2024. And also by that, they have vacated the interim status quo that was also passed by the court itself. Agreed by that again, Lordship, the present civil revision is filed before this court. Lordship, they are narrating to the interim order that has been passed by this court. I am not questioning that. The intention and also the motive of the petitioner has to be examined at this stage, Lordship. What is the motive behind that? Because since 2003, I have purchased the land. And by that, since then, the entire family has been in occupations over the suit land. Not only that, now the suit land, they are saying that we are not claiming the entire land, but only a portion of land. Whether there is any agreement to that effect, whether there is any written records that yes, you had that agreement, nothing. All these are just by way of statement. And Lordship, within the suit land, the reasons why I'm strongly objecting to such status quo order, Lordship. In the suit land itself, I'm running a hostel. I'm running a steel fabrication. I'm running a bakery within the suit land itself. They were not complaining anything for these many years, 21 years, only in the year 2024, this year, March. When I am about to have again further constructions, only then they have come to the court. Time and again, stay has been obtained. Until today, and by this revision petition, they have come before this court. Lordship. Under Article 227, they are before this court. I'm going to place some authorities there. This court has under the purview of Article 227. This court has certain limitation to interfere into the judgment or the order passed by the tribunal below or the courts below. Before going into the question of law, Lordship, certain few facts that is undisputed and agreed by both the parties. Number one, the suit land originally belongs to someone else. That is defendant number two. There was a settlement transactions between the present petitioner and the defendant number two. During that point of time, the present respondent that was offered, we will find in the title suit, in the statement itself. The present being the biological sister. Now I'm the elder sister of the present petitioner. I was offered to buy the land, that land. But see, I don't have the financial capacity to buy it. So for quite some time, they were offering, but I cannot. But finally, I had no other options. And since, as they were saying, my earlier residence that was far away from the motorable road. So it's for that convenient. I sold off my land, my building, everything, and shifted my building, my family to the present disputed land. That was in the year 2003. Since then, I have been in occupations of it. Now my children, my daughter, one of my daughters, she's running a hostel. One of my son who is running a fabrication, steel fabrication. Now we cannot run the bakery, which is also there. But see, just because of the ongoing issues that we cannot continue to run the business. So Lordship, that was the position. They are also admitting that in considerations of I have paid 50,000 against the land for the purchase of the land. We do not know how loan transaction was that was done between the petitioner and the defendant number two. We do not know. But what we know is within our financial capability that we were offered, so we paid 50,000. No document was ever executed and nothing to show in the present writ petition. Throughout the entire the proceeding, no document is there to show that yes, he purchased from them. Nothing. At least I have a document. At least I have document to show. Lordship, while explaining that, this is one objections file, page 102 of the present petition, to the present petition. Page 102. This is the objection filed by the present respondent before the civil judge senior division. Lordship, coming to, because this is important, paragraph 7. Paragraph 7. Before that, Lordship, document is important. Paragraph 6. Paragraph 6. 6 and 7. I have annexed certain documents. Let me read out. Allow me to read. Paragraph 6. That upon purchasing, paragraph 6, page 104. That upon purchasing and taking possessions of the suit land by the defendant number 1's husband. That means I'm talking about my husband. That defendant number 2 affirmed that he had given sold his land to the defendant number 1's husband. Thereupon proper boundaries of the suit land were drawn, wherein elders were consulted for the purpose of confirmation while demarcating the boundaries. Furthermore, in the process of demarcations of boundaries of the suit land, the defendant number 1's husband was also requested to relinquish a portion of his land to Mr. So-and-so, which he agreed in the larger interest of the peaceful coexistence of neighbors in the locality. As such, there and then, the matter was settled in finality. Thus, all such events and persons who bore witness to the demarcations of boundaries and other agreements were recorded, and subsequently a document dated 9/6/2003 is prepared by the defendant number 2 to the said effect. It is pertinent to mention that some of the individuals who bore witness to the said agreement are still alive, and there will be material witnesses in the present case. So I have annexed one document, which is in page, Lordship, which is in page 111, 111. This is a document, 111 and 112. This is one document which was executed between me and the defendant, the original landowner. Then again, paragraph 7. That after the defendant number 1's family took over the possessions of the suit land, the plaintiff used to visit the house of the defendant number 1 from time to time, and the relationship was considerably cordial. During those years, there was not a whisper of claim as to the ownership of the suit land, or for that matter, any portion of the suit land. Besides, even when construction activities in the form of a hostel, a bakery, and a steel fabrication took place in the suit land, but she did not raise any objection. Mention may be made that all these constructions were erected in the portion of land which the petitioner terms as moiety, as per the map prepared by her. Conversely, for the purpose of indication of developmental activities that took place in the suit land after 2003, a post-2003 map is drawn by the defendant number 1. So in page 113, I have prepared a map that after 2003, how much that has been developed. Lordship, page 113, this is the map prepared by us and the present position. Lordship, prior to that, the one map has also the annex by the petitioner. Lordship, I'll find it out. Here, in that map, I have indicated that the boys' hostel, bakery, and the steel fabrication, they are claiming this portion. If there was any agreement between us and anything done subsequently, that is my personal responsibility, my responsibility to return it to them. But there was nothing. And only now, after 21 years, they have come and instituted the present title suit. Lordship, now, coming to the legal positions, how and in what manner this court can interfere into the judgment passed by the principal district judge. Prior to the judgment, the impugned judgment passed by the principal district judge, Lordship, it will be better to first understand whether the civil judge senior division, while passing the order by which they have challenged before the principal district judge, whether that was proper or no, that we'll have to see first. Lordship, page 59. Page 59.
Yes. Continue.
In page 59,
Hmm.
Lordship, instead of going into detail, the civil judge senior division straight away confined to whether the plaintiff has could able to then has satisfied the trial court below in 3 golden principles. Prima facie, whether he has a prima facie case or no, whether he has a balance of convenience in his favor, whether any irreparable loss can be caused to him. That 3 principle was strictly observed. And Lordship, now, the discussions, page 69. That is part of the order. Discussions, decisions, and reasons thereof. Lordship, paragraph 21, 22, 23, 24, 25, 26. These are important, but and 28. Lordship, I will straight away come to paragraph 25. Further, while it is argued by the OP, that means opposite party, that was me, that there was intention of the applicant to sell the suit property to the OP, it is argued by the applicant that the possession was permissive and there was no outright sale. It is further argued that the right, title, and interest is vested on the applicant and that the OP is a trespasser. Therefore, at this stage, the above claim made in the instant application gives reasonable ground to this court to believe that there is a bona fide dispute regarding the suit land in favor of the applicant, and there are substantial questions to be determined in the present suit, which necessarily give rise to a prima facie case to go into trial. This is important, Lordship. The entire case of the petitioner based on this, Lordship. Then 26. Moving on as to whether refusal of grant of interim injunction will cause irreparable loss to the applicant in Dalpat Kumar and another versus Prahlad Singh and others reported in so-and-so, it was held that irreparable injury, however, does not mean that there must be no physical possibility of repairing the injury, but means only that the injury must be a material one, namely one that cannot be adequately compensated by way of damages. In this regard, this court is of the opinion that even if any loss is caused to the applicant, the same would not be of the nature that it cannot be adequately compensated. Hence, this court is of the opinion that no irreparable loss will be caused to the applicant if the interim injunction is not allowed at this time. That was discussed. Then, Lordship, 27. Coming to the condition of balance of convenience, the Honorable Apex Court has held in Dalpat Kumar supra, that the court, while granting or refusing to grant injunction, should exercise sound judicial discretion to find the amount of substantial mischief or injury which is likely to be caused to the parties. If is likely to be caused to the other side if the injunction is granted. If on weighing competing possibilities or probabilities of likelihood of injury, and if the court considers that pending the suit, the subject matter should be maintained in status quo and injunction would be issued. 28. In the instant case, the counsel for the opposite party has stated that as part of the current developmental activities, the steps leading to the opposite party's house has been dismantled, and due to the restraining order, no work could continue as such, affecting free movement. That whereas the applicant is a resident of Chamukadima district, and therefore no loss or inconvenience shall be caused to her by the developmental activities. Further, that with the passing of the ad interim injunction, the constructions of the retaining wall for protections upon the freshly cut earth was suddenly put on hold. The area where the current retaining wall is adjacent to other buildings above it, thereby causing serious peril in destabilizing the entire area. Without proper retaining wall and with the monsoon seasons being on the verge of setting in, there is apprehension that the freshly dug loose soil may trigger landslide of big magnitude, which may cause havoc unless the OP and her husband is allowed to build a proper retaining wall. The applicant encounter is unable to satisfy the court that the balance of convenience is in her favor. On hearing the parties, the court is satisfied that there are more probabilities or likelihood of injury on the OP, given the fact that the house and the business establishments of the OP is located above and adjacent to the suit land and may be subjected to more damage in the event that ad interim is continued. In view of the above, while prima facie case is established, the applicant has been unable to satisfy this court in regard to the other two conditions for grant of interim injunction. In view of the above, the present IA stands rejected. Consequently, the ad interim injunction granted in favor of the applicant by order dated 27/3/2024 by this court stand vacated and set aside. So, Lordship, there is a prima facie case where the suit can continue. Whereas in the findings of the court below, that the plaintiff could not satisfy the trial court in matters of balance of convenience and irreparable loss. In that case, let me take your lordship to again in the case of Dalpat Kumar. Lordship, by this decision, the court has decided the IA. Lordship, may I take your lordship to paragraph 5? Paragraph 5. This will suffice. Paragraph 5. May I read only paragraph 5? Therefore, the burden is on the plaintiff by evidence LUD by affidavit or otherwise that there is a prima facie case in his favor which needs adjudication at the trial. The existence of the prima facie right and infractions of the enjoyment of his property or the right is a condition for the grant of temporary injunction. Prima facie case is not to be confused with prima facie title, this is important, which has to be established on evidence at the trial. Only prima facie case is a substantial question raised, bona fide, which needs investigation and a decision on merits. Satisfaction that there is a prima facie case by itself is not sufficient to grant injunction. Lordship, this is important. Satisfaction that there is a prima facie case by itself is not sufficient to grant injunction. The court further has to satisfy that non-interference by the court would result in irreparable injury to the party seeking relief, and that there is no other remedy available to the party except one to grant injunction, and he needs protections from the consequences of apprehended injury or dispositions, irreparably injury. However, those not mean that there must be no physical possibility of repairing the injury, but means only that the injury must be a material one, namely one that cannot be adequately compensated by way of damages. The third condition also is that the balance of convenience must be in favor of granting injunction. The court, while granting or refusing to grant injunction, should exercise sound judicial discretion to find the amount of substantial mischief or injury which is likely to be caused to the parties. If injunction is refused, and compare it with that which is likely to be caused to the other side if the injunction is granted. If on weighing competing possibilities or probabilities of likelihood of injury, and if the court considers that pending the suit, the subject matter should be maintained in status quo, an injunction would be issued. Thus, the court has to exercise its sound judicial discretion in granting or refusing the relief of ad interim injunction pending the suit. Lordship, the trial court has examined. If injunction is granted, then who will be more suffer? That was observed. If that is not to be granted, who will be more suffered? That also has been examined by the court. And Lordship, by this authority, it clearly covers that. Even though prima facie may be in favor of the plaintiff, if he could not satisfy the court in matters of balance of convenience and irreparableness, that cannot be. Lordship, now coming to the decision passed by the principal district and session judge in appeal, miscellaneous appeal. Lordship, may I take your Lordship to page 21. Starting from page 21, whereas the relevant operative parties only in page paragraph 15 and 16, 15, 16, then 19. Aggrieved by this decision, they have come before this court. Lordship, starting from page 21, that was the statements have been recorded. From page 14 onwards, observations and the findings of the court below starts. Lordship, 15, may I read for all of us? Paragraph 15, page 34. This court has duly taken note of the order dated 17/4/2024, passed by the learned court below, whereby the learned court below, in exercise of its equitable and discretionary jurisdiction, has vacated and set aside the interim injunction for the purpose of grant of injunction. The three golden principles needs to be satisfied. That is, a prima facie case to go for trial, balance of convenience is in favor of granting the injunction. And if injunction is not granted, an irreparable injury would be caused, which cannot afterward be compensated by any degree which a court can pass as a result of the cause. 16. Before discussing the present appeal, certain facts and issues were raised by the counsel for the respondent, that the nature of claim is merely a monetary recovery dispute, which should be filed by way of money suit, and the schedule of property was not sufficiently defined by the appellant in the suit as mandated under Order 7, Rule 3. More so, he submits that the title suit is filed after 21 years and barred by limitation, and the husband of the respondent in whose name the suit land has not been made a party. Suit has not been made a party. Not the original court. This court has very limited jurisdiction to deal with such facts and issues raised at this stage. In this appeal, this court has also taken note that the title suit number is pending before the learned court below, where the parties are represented by their counsel. In the so again, reproduce of the findings of the lower court below. Then coming to the paragraph 19. Paragraph 19. Now, whether the learned trial court below exercise its discretionary judiciously in vacating and setting aside the ad interim order dated 27/3/2004, while impugn order dated 17/4/2024. In this regard, this court finds it relevant to take note of the judgment of the Honorable Court in the case of Wonder Limited and another versus Antox India Private Limited, reported 1990 supply SCC 727, where at paragraph 14, the apex court observed that the appellate court could not interfere with the exercise of the discretion of the court of the first instance and substitute its own discretion, except where the discretion has been shown to have been exercised arbitrarily or capriciously or previously, or where the court had ignored the settled principles of law regulating grant or refusal of the interlocutory injunction. Keeping in mind that, Lordship, the paragraph 20. The learned court below observes in the impugn order that the claim made by the appellant in the instant applications give reasonable ground to this court to believe that there is a bona fide dispute regarding the suit land in favor of the applicant, and there are substantial questions to be determined in the present suit, which necessarily give rise to a prima facie case to go into trial. With regards to the principle of balance of convenience and irreparable injury, the learned court below observed that the applicant encounter is unable to satisfy this court that the balance of convenience is in her favor. And on hearing the parties, there are more probabilities or likelihood of injury on the opposite party, given the fact that the house and the business establishment of the opposite party is located above and adjacent to the suit property and may be subject to more damage in the event the ad interim is continued. In the case of Dalpat Kumar, so-and-so, reported in so-and-so, which is referred by the parties, the Honorable Supreme Court held that while granting or refusing to grant interim injunction, the court should exercise sound judicial decision to find the amount of substantial mischief or injury which is likely to be caused to the parties. If the injunction is refused, and compare it with that which is likely to be caused to the other side if injunction is granted. So, Lordship, going by it, Lordship, The court below, the principal district judge, Kohima, has rejected the appeal that was filed by the present petitioner appellant, stating that and observing the decision passed by the civil judge senior division, where that no illegality has been committed by the court below, for which they have also the substitute its own discretions, and lordship that way. The appeal was dismissed, and against that dismissal order, they are before this court. Lordship, Supreme Court, the apex court has in numbers of cases that how to exercise Article 227 by the Honorable High in while any revision has been filed against the decisions passed by the tribunal or the court's below. Lordship, may I take your lordship to one authority that reported in the case of Osep, Methai and others versus M. Abdul Kadir, reported in 2002, 1 SCC 319. Lordship, straight away, may I take your lordship to paragraph 4. 4 and 5. 4 and 5. I may be allowed to read. It is not denied that the power conferred upon the High Court under Article 226 and Article 227 of the Constitution are extraordinary and discretionary power as distinguished from ordinary statutory powers. No doubt, Article 227 confers a right of superintendence over all courts and tribunals throughout the territories in relations to which it exercises the jurisdictions, but no corresponding right is conferred upon a litigant to invoke the jurisdictions under the said article as a matter of right. In fact, power under this article casts a duty upon the High Court to keep the inferior courts and tribunals within the limit of the authority and that they do not cross the limits, ensuring the performance of duties by such courts and tribunals in accordance with law, conferring powers within the ambit of the enactments, creating such courts and tribunals. Only wrong decision may not be a ground for the exercise of jurisdictions under this article unless the wrong is referable to grave dereliction of duty and flagrant abuse of power by the subordinate courts and tribunal, resulting in grave injustice to any party. Paragraph 5, numbers of cases have been now referred in this case. Paragraph 5, in Variam, Singh and Amarnath, this court held that power of superintendence conferred by Article 227 is to be exercised more sparingly and only in appropriate cases in order to keep the subordinate court within the bounds of their authority and not for correcting mere errors. This position of law was reiterated in Najendra Nath Bora versus Commissioner of Hills Divisions and Appeals, in Batuk Mal Raichand Osmal versus Lakshmi Bai R30. This court held that the High Court could not, in the guise of exercising its jurisdictions under Article 227, convert itself into a court of appeal when the legislature has not conferred a right of appeal. After referring to the judgment of Lord Denning in R versus Northumberland Compensations Appeal Tribunal, ex Shaw. This court in Chandavarkar, Sita Ratna Rao and Ashalata S. Guram held. It is true that in exercise of jurisdictions under Article 227 of the Constitution, the High Court could go into the question of fact or look into the evidence if justice so required it. If there is any misdirection in law or a view of fact taken in the teeth of preponderance of evidence, but the High Court should decline to exercise its jurisdiction under Article 226 and 227 of the Constitutions to look into the fact in the absence of clear and cut down reasons where the question depends upon the appreciations of evidence. The High Court also should not interfere with a finding within the jurisdictions of the inferior tribunal, except where the findings are perverse and not based on any material evidence or it result in manifest injustice. Except to the limited extent indicated above, the High Court has no jurisdiction, in our opinion. Therefore, in the facts and circumstances of this case, on the questions that the High Court has sought to interfere, it is manifest that the High Court has gone into questions which depended upon appreciations of evidence, and indeed, the very fact that the learned trial judge came to one conclusion and the appellate bench came to another conclusion is indication of the position that two views were possible in this case. So, Lordship, this is one case. Then in 2022, in the case of Garment Craft versus Prakash Chand Goyal. Here also more or less same, but the jurisdictions of the High Court to be exercised under Article 227. Lordship, paragraph 14th and 15th. 14 and 15th. 15th, the Lordship. Having heard the counsel for the parties, we are clearly of the view that the impugned order is contrary to law and cannot be sustained for several reasons, but primarily for deviation from the limited jurisdictions exercised by the High Court under Article 227 of the Constitution of India. The High Court exercising supervisory jurisdiction does not act as a court of first appeal to reappreciate, reweigh the evidence or facts upon which the determination under challenge is based. Supervisory jurisdiction is not to correct every error of facts or even a legal flaw when the final finding is justified or can be supported. The High Court is not to substitute its own decision on facts and conclusion for that of the inferior court or tribunal. The jurisdiction exercise is in the nature of correctional jurisdictions to set right grave dereliction of duty or flagrant abuse, violation of fundamental principle of law or justice. The power under Article 227 is exercised sparingly in appropriate cases, like when there is no evidence at all to justify, or the finding is so perverse that no reasonable person can possibly come to such a conclusion that the court or tribunal can come to. So, Lordship, let me go a little further. It is axiomatic that such discretionary relief must be exercised to ensure there is no miscarriage of justice. explaining the, paragraph 16, explaining the scope of jurisdiction under Article 227. This court in Australia Rubber Das Estate Private Limited has observed the scope and ambit of exercise of power and jurisdictions by the High Court under Article 227 of the Constitution of India is examined and explained in a number of decisions of this court. The exercise of power under this article involves a duty on the High Court to keep inferior court and tribunal within the bounds of their authority and to see that they do their duty expected or required of them in a legal manner. The High Court is not vested with any unlimited prerogative to correct all kinds of hardship or wrong decision made within the limit of the jurisdictions of the subordinate courts or tribunal. Lordship, let me not go further because the principle is same. So, Lordship, whether the petitioner has met out in the present revision petition that the court below has committed any grave derelictions of duty, or whether they have made out the case in such a way that, yes, the court below has flagrant abuse or violations of any fundamental principle of law. That has not been made. They were referring to the facts, how that has been started. But this court has a limited jurisdictions to exercise its power under Article 227. So, Lordship, instead of going any further, the present revision petition is not maintainable, has got no merit, because, Lordship, this appeal was already the decisions of the trial court, while vacating the ad interim, has already and minutely discussed. And the three golden principles that was make it very clear. So I pray that the present revision petition may be dismissed.
Lordship, may allow me to rebut certain contentions raised by you. First, regarding the maintainability of the petition, I just want to rely on one decision passed by the coordinate bench of this court. This was on 14/3/2024, the first paragraph only. Now, here also similar facts where the injunction was rejected. They came for appeal under Order 43.
Stressing on para number.
On first paragraph only, where they have filed a revision petition under Section 115 of the CPC. Now, the law is well settled that 115 against interlocutory orders are not maintainable, and then this Honorable Court was pleased to convert, even though not, it was pleased to convert the petition under 115 to 227. As far as the maintainability is concerned, 227 is very well maintained. On the my apologies, but I forgot to place, and I prepared an index for your Lordship's convenience in referring to all the applications and orders which we are referring to, which the parties are referring to. Regarding the, I don't want to enter into the facts again, but regarding that document which was earlier relied upon by the defendant number one.
One agreement was there.
Yes.
One agreement.
Yes, one agreement. I filed my objection before the 11th High Court, saying that this document is completely fictitious and absolutely unreliable. Now, your Lordship will see that at page 111, that document has been enclosed, and even though I have filed in my objection, I've clearly stated as to why it's fictitious. Allow me to just show your Lordship just one or two aspects of the matter. At page 111, where the defendant number one filed this agreement in his objection to my application for injunction. Now, your lordship may come to the next page. Purportedly, it has been signed by the defendant number two and his wife. Now, your lordship has already seen that in the written statement, they have stated clearly that they have transferred the land to the plaintiff. It's dated 9/6/2003. Your lordship may note that 9/6/2003 signed. But in the agreement, in the previous page 111, lordship will see that in the second paragraph, here again the date, in this regard, on 3/5/2005. And it's written in word, 3rd day of April 2005. And again, if your lordship can come to the third paragraph, starting with the word following. Following came to the meeting on 3/5. The third paragraph at page 111. Your lordship has got it?
Oh.
At page 111, I would like to show your lordship the third paragraph or the third line. Following came to the meeting on 3/5/2003 again. Now it's completely unreliable. Now the defendant in his objection to my application for injunction, they have admitted that there was a settlement transaction between the plaintiff and D2. Again, they take a contrary stand that they have paid 50,000 to the plaintiff. Now they rely upon this document. Purportedly dated 2003. Let them prove it before trial. These are questions of facts. But the learned trial court, what I'm submitting is that the learned trial court has clearly held that this document at this stage cannot be relied upon insofar as the claim of the D1 is concerned. Now, secondly, on the aspect of course, the D1 relying on this document claims that there's a 21 years delay in filing the suit. Of course, these are all questions of facts again, but in the plaint, it has been clearly averred to. And the D1 can raise all necessary objections insofar as the limitation is concerned. Your lordship knows very well under Order 711. And whether the dispute of this manner is maintainable or not, allow me to just cite your lordship one authority of the Supreme Court. This is now in this case also there was an oral agreement. I'm relying on paragraph 2, 3, relying on 2, 3, 4, 7, and 15. 2, 3, 4, 7, and 15. In short, here also in this case, there was an oral agreement between the plaintiff and the defendant. Defendant did not perform a part of the contract, but gave only a part of the amount to the plaintiff. Plaintiff, upon requesting the defendant to pay the amount, the defendant refused. So the plaintiff filed a suit for possession. Now the trial court granted it, the High Court reversed the decision. Supreme Court says no, the High Court's decision was wrong and the trial court's decision was right, saying that degree of possession can be maintained. Now this aspect of the matter is found in under the case of the plaintiff, and my case also, it's rooted under Section 39 of the Contract Act, where the lordship may have, should I read it or? Yes, Contract Act.
You have here?
Contract, yes, 1872. Section 39. Section 39 says, effect of refusal of party to perform promise wholly. When a party to a contract has refused to perform or disabled himself from performing his promise in its entirety, the promisee may put an end to the contract unless he has signified by words or his conduct his acquiescence in its continuance. Now, in the facts of the case, in 2012, I put an end to the contract, to the whole agreement. Because you refuse to pay the remaining sale consideration, I'm putting an end to our whole agreement. Thereafter, of course, the plaintiff did not file a suit. But in 2014, a slight incursion was made where the plaintiff directed the defendant number one to lay off the land. Only in March 2024, your lordship will see that the defendant number one started denying the title of the plaintiff.
Okay,
Yes.
that's how you,
Yes,
the
that's
cause
how
of
the suit
action
has been brought
for-
about. Just to show, I will not be taking the lordship to the paragraphs, but similar facts, all transactions, and and that is why the plaintiff suit is covered, is well covered by the decision of the Supreme Court. Now, regarding now the trial court, at the course of a petition, the trial court has held that prima facie case is established. Now, prima facie case does not only mean that there's a substantial question of law to be tried in trial, but in Dalpat Kumar's case, since your lordship has already held, lordship has already have the decision, I would like to take your lordship to paragraph 4. Paragraph 4,
Dalpat Kumar.
Dalpat
Paragraph
Kumar's 1992 1 SCC
Yes.
719. Yes. It's not just that there's a substantial question to be tried in trial, but the other aspect of the matter which the trial court has missed is at paragraph 4 in the next page 721 of the report, Placitum A. The exercise thereof is subject to the court satisfying that there is a serious disputed question to be tried in a suit, and that an act on the facts before the court there is a probability of his being entitled to the relief asked for by the plaintiff or defendant. Now, this is another aspect which the trial court has taken into consideration. Now, imagine if the plaintiff, finally a suit is decreed in favor of the plaintiff. Now, imagine letting the defendant number 1 continue with all the construction activities that she desires to in the course of the suit. Now, we don't know how long the suit will take. 5 years, 10 years, 2 years, 3 years. Now, in the meantime, if the defendant number 1 is not to construct whatever permanent structure that she desires, then that will cause severe prejudice to the plaintiff when already a prima facie case has been held to be established by the trial court. Now, this aspect has been missed, and that is the only submission that the plaintiff has been making the entire time. This aspect has been missed. It's not a question that the defendant has continued with the construction or 50% of the construction has completed. Now, in that aspect of the matter, the balance of convenience and irreparable injury are different. But this is a case where the work has not even started. It's about to start. The RCC pillars have been erected. But in view of the defendant number 1's plea or prayer seeking to construct the retaining wall in view of the oncoming monsoon and damage, which was the apprehension of injury which was expressed, the learned trial court could not balance the interests of the parties. Now, if at all the learned trial court could have said that you go on with the retaining wall, but as far as the other construction activities are concerned, do not proceed. At least that could have solved the matter as far as the balance, as far as the interests of the parties are concerned. So that is the only aspect of the matter where the plaintiff is agitating before this court again. Therefore, if at all the defendant number 1 is allowed to continue with the construction activities as she has been doing, then that will cause serious prejudice and injustice to the plaintiff. And the nature of the suit property, the lordship will imagine how the trial court has held that it can be compensated, but how? Imagine after 10 years, the suit is decreed in favor of the plaintiff. How is it to be compensated? As far as the retaining wall is concerned, I have also made a prayer in the petition because I've considered to the defendant number 1's request to construct the retaining wall. I've made a prayer in this petition at page 17. Yes. Page 17. Page 17, my prayer C. Pass an order to the effect that the petitioner shall not be held liable to compensate the respondent for any construction activity undertaken by the respondent on the suit property if the title suit is decided in favor of the petitioner, and the respondent shall be bound by the decision of the suit to be decided on merits later on. Now, in this regard, just one citation. Just one paragraph, paragraph 32, where the equities, where the Supreme Court has also held. Now, in this case, the construction was such that it was of a huge magnitude where the construction could not be stayed. But in this case, the trial court has held that equity will have to be maintained. Now, the defendant will have to be, he'll have to, or she will have to bind himself to the decree, which will be subsequently granted in the suit. Now, therefore, even though a retaining wall has been constructed, it is over. With your lordship
Here in this
permission.
case, you're emphasizing on para, which.
32, sorry, 32, where the equity has to be balanced. This is the retaining wall, now it's over. Therefore, my only prayer is that at least in the during the pendency of this, status quo may be maintained and no further construction activity may be allowed on the suit land. I'm deeply obliged.
You've completed, I think.
One clarification, just one. See, then now the present proposed construction, that construction activity, this is a continuity only, continuity of the activities that are taking place. As I've said earlier, steel fabrication building is there. Bakery is there. Then a hostel is there. This is just a continuity of that. So Lordship, if there is any status quo or any injunction has been passed against us, then see that when comparing with the plaintiff to be suffer, who will suffer? My entire family is there. And as I've mentioned here, he is residing somewhere else. My entire family is there. My livelihood is coming from there. If any injunction is passed against us, then the serious injury that will cause to us, that is the issue.
That aspect, I have no objection. They can continue. If there is a bakery or if there's steel fabrication, they can continue with that. Those are all kata structures they have admitted in their objection to my IA. They can continue with that. But no other permanent structure should be continued. Lordship knows very well the
This
balance.
court has a limited power to.
Okay, make it CV, I'll pass you order.
Yes.
All right.
Is anything anymore? List is over? Okay. In 15 August, you also come or probably bar members also come? Generally, in 15th of
15th
August,
August.
online any?
I hope so. Yeah, some of us will be joining. Yes.
I'll be here for the first time in 15th August.
Yes. It's a little
Maybe. No, sir.